Losing a loved one is one of the hardest experiences in life. Amidst the grief and memories, the last thing any family wants to face is a complicated legal battle over the estate left behind. Yet, without a clear plan, that is often what happens. Securing your legacy and protecting your assets comes down to choosing the right estate planning tools. Today, we are breaking down the ultimate debate, the living trust versus the traditional will. Which one is truly better for you and your family? Please note that the information in this video is for educational purposes only and does not constitute legal advice. Every family situation is unique, so we strongly encourage consulting with a qualified estate planning attorney before making any decisions. Let's start with the last will and testament. At its core, a will is a legal document directing how your assets are distributed after you pass. It lets you name an executor to handle your affairs and nominate guardians for minor children. While relatively simple and inexpensive to create, a will requires probate, a public, court-supervised legal process. This brings us to the living trust, or revocable trust. Unlike a will, it takes effect immediately. By holding your assets in a separate legal entity, a living trust avoids probate entirely, offering your family much greater privacy. It also provides management during incapacity, allowing a trusted individual to seamlessly take control if you become ill or unable to manage your own affairs. While offering robust protection, a living trust is more complex and expensive to establish. Crucially, it requires funding. This means you must officially transfer your bank accounts, real estate, and other assets into the trust's name for it to work. Ultimately, choosing between them comes down to your personal goals. When it comes to estate planning, many assume a will is the final word, but a will is actually an admission ticket to a legal process known as probate. Probate is a court-supervised procedure that validates your will, pays off debts, and distributes your remaining assets. If you rely solely on a will, your family is forced to go through the court system to settle your estate. Probate can be a major puzzle for your heirs. First, it is time-consuming, often taking several months to a few years to complete. Second, it is costly. Attorney fees, executor fees, and court costs can drain a noticeable percentage of your estate's value. Finally, probate is public. Anyone can access court records to see what you owned, who you owed, and who is inheriting your wealth. This is where a living trust shines, as it is designed specifically to avoid probate entirely. Because the trust legally owns your assets, there is no need for a court to validate the transfer of ownership. Instead, your designated successor trustee seamlessly and immediately transfers assets directly to your beneficiaries. This saves significant time, preserves your estate's value, and keeps your family's matters completely private. Let us look at a concrete example. Suppose you own a primary residence in California and a vacation home in Florida. With only a will, your family faces probate in California, plus a secondary ancillary probate in Florida. By placing both properties into a living trust, your successor trustee manages and distributes both homes without stepping foot inside a single courtroom in either state. Planning for the unexpected means preparing for what happens if you become unable to manage your own affairs due to a severe illness or injury. When facing sudden incapacity, the difference between a will and a living trust becomes extremely clear. Remember, a traditional will only takes effect after you pass away. If you become incapacitated, it offers zero provisions for asset management. Your loved ones could be forced into a lengthy, expensive court process to have a conservator appointed to handle your finances. A living trust, however, provides a built-in safety net. If you lose capacity, your designated successor trustee seamlessly steps in to manage your trust assets, avoiding the courts entirely. Your financial affairs are handled exactly according to your wishes, allowing your family to bypass legal battles and simply focus on your care. One of the most overlooked differences between a will and a living trust is privacy. When you pass away with only a will, your estate goes through probate. This means your last wishes, asset details, and beneficiary information are filed with the court and become completely public record. Anyone, from nosy neighbors to financial predators, can look up exactly what you left behind and to whom. A living trust, however, operates outside of probate. It remains a private agreement, keeping your family's financial affairs completely confidential and secure. When comparing a will and a living trust, upfront costs and complexity differ significantly. A will is generally the less expensive, simpler option to quickly put in place. In contrast, setting up a living trust requires a larger initial investment of time and money, involving detailed legal paperwork to properly fund the trust with your assets. But the upfront price is only half the story. A simple will must go through probate, a public legal process that incurs significant court fees, attorney costs, and executor compensation. Depending on your state, probate can consume anywhere from 3 to 8% of your total estate value. Because a living trust bypasses probate, it saves your family substantial money long term. Let's look at the numbers. On a $1 million estate, avoiding probate could preserve up to $50,000 that would have otherwise been lost to administrative and legal fees. For larger estates, this makes the higher initial setup effort well worth the investment. Creating a living trust is only half the battle. To make it work, you must complete a critical process called funding. This means officially transferring the ownership of your assets into the name of the trust. Funding involves practical steps like retitling real estate deeds, bank accounts, and investment portfolios. For example, you will need to sign a new deed to transfer your home into the trust, or work with your bank to update your account ownership. While most assets belong in the trust, retirement accounts usually rely on beneficiary designations instead. To catch any assets you might have forgotten to transfer, you use a pour-over will. Think of it as a safety net, funneling leftover items directly into your trust. Choosing between a will and a living trust comes down to your unique circumstances. Ask yourself, how large and complex is your estate? Do you value keeping your financial matters private? Will you need someone to manage your assets if you become incapacitated? You must also weigh upfront costs, potential family conflicts, and how your specific state laws handle probate. Often, the best strategy is actually a combination of both. Enter the hybrid approach. By pairing a living trust for your major assets with a pour-over will, you create a safety net that catches any remaining property, ensuring comprehensive coverage. Ultimately, deciding on your estate plan is a highly personal process. Before making any final decisions, always sit down with a qualified professional. Choosing between a will and a living trust comes down to your goals for probate, privacy, incapacity, and costs. Always consult an experienced estate planning attorney to build the perfect plan for your family. Visit funeralist.com/directory to find your local probate courts. If this guide helped you, please like, subscribe, and leave a comment below. Thank you for watching, and here is to securing your legacy.